around adu saaf kale beta
adu leba
adna on screen share nakura එහෙම ගන්න on screen fene eta me lecture ga around boda focus kuran gas kurani law of tort not the law of torts ke terrain armenna miha kana kuri lectures takka cover in detail yes ade me in detail cover nukure kuri areas taka migoton me lecture around structure ko fonnani migota em furtama me private law of obligations ka tort law me fit wani kontakatto me kommak sada ganitto me ke tafsil ustad visham lecture ga wadefani around war khulasa gotekka eba cover kurana dengege fahum on focus kurana tort law remedies so then me lecture ga hama maganu gotekka around hama fahaga ko around me balani hama remedies perspective bakun then me hori torts taka syllabus tere me torts taka then ege turun negligence ke terega around faha karave syllabus ge boy me consequential damages api or economic loss ke waha ka dege tura damages for personal injury ke waha ke me e bayan around negligence ke ba focus ko fa nani ege turun defamation ga around me by kankan around hum faha kollana adi in conclusion around vicarious liability ke waha taka adi ge esta around balalana then mihin around me cover curious hama me tort law remedies ke terega employers liability ke kankam ge wahaka faha kuregen dane adi me hin me tortious liability ke hin bathaka around balalana then vicarious liability ke strict liability tort kawati kommasaraka strict liability kankam ismege tere around menna pelegenda so emme furitama me private law of obligations no the mihung machan upade zimma taka gule private law ge area ga mihung machan upade zimma taka gule kanuna bala iru ebbayaka law school ga harme me kiyawani contract law then tort law then ege timmana bayen e bobe enames me ammu gotegga law school takon cover kura area no contract law me consent based ko onna duty create wegen da daira tort law me loss based e mihe kallibe gellumen not mihe duty eka not mihe haggaka aragatuma guligen libe gelluntaka gule daira demyonnani the law of restitution of the law of unjust enrichment me gain based duty mige misalen alwan dannawalema me tota restitution na hori tafat komusaraka saafegen dana kannenge misalaka alwan oligen miheka fasai transfer kurevuni emihange benge me oligen libunu fasta kan suwalaki e duty create wegen annani kiha hisabakun to ena gohen hadagen hodi fasta annun ene oligen alugandan oligen ene fonunu fasta en ei එනමසේ රද්දුකුරුම්ගේ සිම්මයි ගානුනි ගතුමු ෆිදිකින් එබදේ ඒ හගීගතුක එක්ෆද මස්සල්තම් විදනි law of unjust enrichment ke tereya in practice mithin daira sekatana kachaibo overlap way then alonmenge mieduge lecture ge focus community mege tereng mi tort ge tereya wanna kankamuge kankama tort law remedies alonmen balaero overview en alonmen denya dibheraje context ga naga debe farwata kan alonmen balanya maganu gotekka de bawate ebo koi eteren furitama bawat ki damages ke tereng dibheraje ga naga de magandu farwa ki compensatory damages ten ege tereng bewade aggravated damages ei komisko hen hetumu ganot tort commit kurumuga amal kuri gotakun mihaka ituru wegenda mental distress ke damages e sama compensatory damages ke terege himineche then ege iturun diveharaje ke banaga de punitive and exemplary damages mi lecture galon cover puranam ege mi naga de area ka naga din furusato oi en area ge waka then devana bavat ke remedy ki injunctions ei mi debawaten ebahimene a mandatory injunctions come kuruma kura amurta then prohibitory injunctions come and mukuruman wata come taluma come prohibit ko nere amurta compensatory damages are bala iro ege underlying principle ge wahaka divheraje gina hukum takako dakkafe ne ehnamas divheraje ge civil court on koppa oin hukume farzana hussein and another versus w construction a reading list ke semine hukume 3143 series idehas nawara e gaziya ga hawala di fe boy ingresi gaziya kan a livingstone versus royals coal company 1880 ඒ ගාසියාග Lord Blackburn විදාළ ෆමියොන්නනි මේ compensatory damages के objective ඒ general objective around මේක පහක් කළාන මේ general objective එක වීම ඒගේ තෙරයන් ඉතුරු factors තකෙන් එබවදේ අදි බයෙන් හාලතක බයි කහල cases ka මේ general rule ලුන් analyze කරන් උලෙජ්ජයා කොම්මසරක common sense අදුරක් දෙවේ හාලතේ සන්නාන එහෙම මේ general rule එක හැම ගින cases ka maybe like 80% of the torts ka this will be the essential principle so me summary ki the object of awarding damages is to put the innocent party in the position that he would have been had he not sustained the wrong e gohen nuhinge nama e madane gohe suffer nupuri nama ena hunnana halata gengos dinu this is the general rule. This is subject to other principles. I will emphasize that because this could mislead. Then devana kamaki compensatory damages ke me damages SS Kurani kon tarikh kunto me gaves me am usulaki a damage suffer vi tarikh wata eronge maaf ka damage na eronge hingi tarikh a breach of duty hingi tarikh ei at the outset the starting point ehen namaves buying halat takuga miya mean eba dura deve ei mi misalaka mege dihahar kurin suffer fellosse e miharo ege badal naga dinuma hame misalaka portugal asunta ken hingagen nuta enuma sababe wegen miharo e badal naga de iru eduhu e mi cost of repair ge value huri adada mihar huri adada wara bodutan tafat vechcheya miharuge tarihun damage ss kurumge fursato adi e bar court taka libigen ve so where it is necessary to depart from the date of assessment in order to adequately compensate the claimant for the damage suffered the courts can and should depart from the date then around kurim faha kolling me ituru factors take gewak mege tereng magandu f factor and mihar gina kaum takuga emme debate kurave f factor ki scope of duty ki me amu gotegga around men gina cases ka hunnani negligence a gule goton ehen numbers in analogous cases eya eggoy ehen cases ka enaga machan enna duty ge scope ki kobato analyze kurun me khulasa ko dannawanya me what scope of duty is misalakon around dannawalana ehnama saronama kurems pa kuren around jehe me moldiven context meeti ifete go hamokoden hagegatuga me beruge hukumtaka around hawala dinas me legal principle laki ekach so misalaka me Khan versus Meadows ge facts ma muhimme non eka ehnama egen establish genda gaanuni usul me muhimme cheki So Han versus Meadows ga kan hinga dia gotaki dehas high ga mammeko doctor ge lafa mi hodani enage mi enaki hemophilia gene ge carrier etto bala negligent doctor kan nuvinama what a negligence nennama he would have advised her me genetic testing atta but he did blood tests and he advised that the child that she conceives will not have hemophilia. 4 years later, the mother became pregnant, and shortly after birth, the child was diagnosed as having hemophilia and autism, which was unrelated to the hemophilia. The mother was referred subsequently to genetic testing, and this revealed that she was a carrier of the hemophilia gene. 2006 ka but for testing I remember yeah 2006 ka if the doctor had referred her to genetic testing she would have known that she was a carrier and she would have also undergone fetal testing for hemophilia when she became pregnant. And on the facts it was shown and on the evidence it was proved that if that had been the case, if she had undergone fetal testing and found out that the child had hemophilia or another genetic disorder, she would have terminated the pregnancy. That was what the facts were. The doctor halatuga he admitted she was liable is something that she accepted with regard to the additional costs associated with the hemophilia, but the doctor denied responsibility for the costs associated with the autism. But for testing harming hamekan nimma lafiya mige conclusion naki hama ingresi me high court sa conclusion if the doctor had advised correctly she would have gone for genetic testing, she would have done fetal genetic testing and other tests, and she would probably have terminated the pregnancy. And high court ekota dekigen ekota hukum kurima appeal kuri court of appeal ya khilafa nimmi court of appeal nimmani enage a duty ge scope ke teriya kannuwade ye autism gule mi kankame enage e duty ge scope ke tere goti hemophilia gule kankame eye ena me advice ding risk ki, so he cannot be the doctor cannot be held liable for the costs for the autism, but the doctor could be liable for the hemophilia. This was appealed to the Supreme Court as well, and Supreme Court conclusion was the same as the Court of Appeal. And they did give us, for our purposes, very helpful guidance, especially when dealing with questions of negligence. And this is not exhaustive. You should keep in mind, this is a general test and or a general series of questions. This is not exhaustive, this is not conclusive, there will be other things you will need to consider, but this is helpful. So the first question is the harm actionable? Basically a farwa devena for the go hetto ganone goton e masala goti negligence, so negligence ke farwa e deve kahala gellumetto devana suwalege goton mi e duty ke scope ki kobato kon hammegge riskakatto e lafain dini timmana suwale gotum hama miharu dibe rajyege smiyonna suwalu miyonnani e duty metto ade duty ge breach etto kureve suwalu hataruwaneya me balani factual causation etto clearly me masala factual causation so then miga tafatu mi suwalege gotuga faha kurevege midiye faswana suwalu a secura damages sa a duty ge scope demeduga hoy kulumaki gulumen ebetto a scope ke tere one damages to a me kiyani the duty nexus question a duty ya damage ya demeduga gulum adi e ge tere one echitto no tanunto then pahuswala gotum ahaswalaki basically remoteness mitigation mi usul taka riya kurairo ei nagade vidane badaletto. Then e masalaga ingress Supreme Court way is mi hasuala jawab tifa economic cost of caring for a child are clearly actionable. දෙවන සුවල් hey duty ge scope ega bayank fonnani Dr. Khan's advice was concerned with a specific risk, and that was the risk of a child having hemophilia, for which Dr. Khan ordered duty of care to Miss Meadows. Dr. Khan was in breach, there was factual causation, and the law did not impose any duty in related to unrelated risks such as autism, which might arise in any pregnancy. There was not sufficient consideration between Dr. Khan's duty and the autism for there to be any justification for making Dr. Khan liable for it. There was no question of remoteness and or other effective cause or mitigation of loss, and the doctor was found liable for the damage, that is the increased cost of caring for a child with hemophilia. Me duty me negligence ke terega duty agule gutum nimma fe masale hinama sama ehen duties taka agule gutum mes e duties ke scope belumaki essential kame komme hen kuranji he kame ehen nuni denne ehen but for causation nun gos me duty ke tere nuwanna etake badal take negumge furusate ba ade ekam prevent kurumge gutum onna usule me scope of duty ge usul. Then remoteness agule gotum ham wara summarily kalon dannawalana. The general test for remoteness of damage in tort is whether the kind or type of damage suffered was reasonably foreseeable by the defendant at the time of the breach of duty. Ega muhimmi egellumge baave egellumge minwar muhimmennu egellum vi specific gotebbes muhimmennu ega muhimmi e baavataki foreseeable bavategge gellunto efada halategga at the time of the breach of duty. Then miya gulige hama mi divhe rajyege gina hukum take hagiyatku mi area kunne ehem wima mi common law principles taka mi balani and common law principles ke usulta divhe rajya court takum wakin hasuko miharuge kaziyata kom avenne fene bala ganna adi if you look at mihar reading list ge me fahon nimma fana masataka bala fiya sama as a matter of principle ei bala ganna usulta ke gotuga fenna muri. And also, I'm a law school of us. I am pretty sure you would have covered this, the thin skull rule. It's not a defense to say the person was more frail. You take the victim as he or she was, and me authority gotuga on site of Owens versus Liverpool Corporation ge masala me Lord Justice Mackinnon and it is no answer to a claim for a fractured skull that the owner had an unusually fragile one. Compensatory damages ka around cover purana batha any muni then around dana punitive damages and this is something divharaje context ga clearly cover puraviginda ei divharajyege king area ga punitive damages naga devidane kama divharaje court ta nimma fa eba huri court ta tribunal ta nimma fa huri adi e gazia takuga hawala difawa wakin hasaka 3143 CVC dehas nawaraga hawala difawa masale e ingress vilatuges authoritative case e Rooks versus Bernard e masalage hukumuga punitive damages naga devene thing halaten vekkama Lord Devlin vidala nani furatama halat ki oppressive, arbitrary or unconstitutional actions by servants of government. Amalaki me divharajyege me civil court me koffain hukumegga hey 1143 CVC dehas dihe Yamin Abdul Qayyum versus me Police Service masalaga e masalaga hey zulm veri gotaka hey oppressive gotaka nota arbitrary gotaka me dawlatuge idara ekon nota sarkaruge barakon nota sarkaruge idara ekon amal koffain halatekka me punitive damages naga difa ebave ei fulhonge amalaka eyako then devana halataka miyonnani where the defendant's conduct was calculated to make a profit for himself මේක මුහිම්ම නෝන් මේ ඉෂෙන්දගෙන් ඉඳගෙන් මේ calculation එක හදා පාතිමන්නේ මේක මේ මෙවරක මක් ෆෑන් එබේ එහෙනම් මේක මුහිම්ම එබේ ඒන ඒ අමල කුරි කොතබ් බලා ඉරු ඒන එපදන් ඒ අමල කුරි ena misal ka liable wa halate ka denje compensatory damages bore ena libe faada boduwana kama qabul kurevigen to එහෙන් බලාහතක මිසාලක ඒන ගබල් කුරේ ෆොති නොත ෆැක්ටර්ස් තකුන් වෙස් පෙන්නන් ඔති හදි හෙකිතකුන් ස්පෙන්නන් ඔති ඒන එෆදෑන් අමල් කුරී ඒන පේ කුරන්ජේ කොම්පෙන්සේෂන් පේ කොෆ්ෆ වෙස් ඒනක මාබුඩු ගෙල්ලුමෙන් නොයේ ඒනෙන් අදිස් මම්ෆා ගෙමෙන්නනි එෆදෑන් අමල් කොෆවා කම දේහ කොත් දෙවිච්චෙයා මී පියුනිටිව් ඩැමේජස් නැගෑද විදාන හාලතේ then timman halataki where statute expressly authorizes the same around ka hama gams pa kure fenne dive rajyege me evs qanunega specifically punitive damages nagade vidana kama bunefa hoy kamaka then dive rajya context bala around kuring hawala de masale 1143 series idhas dihe yam nabdo qayyum versus smallest police service e masalaga me for e masala me fall wani Rooks versus Bernard category ta teren furitama category en oppressive arbitrary or unconstitutional acts by servants of the government e masalaga nagadi from yonnani 41,600 rupiah me calculation hedumuga bala from yonnani Ingres Vilatuga mifada halataka nagade adaduge 1/3 then me 1/3 ge wahaka me lecture ga de takurarugen dane then fahun around ege tafsilan around dana devana bawatuge case punitive damages nagade devidana halaten oi kama devege civil court on fahaka feke ka fahag me kureni Farzana Hussain and another versus W Construction Company මීග punitive damages naga defend we ehna mes e court ge hukuma balaro e naga devitana halate kama dehawa mi wahakaken e bahuri megoton em furitama e masala ge babe hawala di for Rooks versus Bernard principle la e masala ge punitive damages naga nudin sababe ge gotukame onnani kumfuni ge muwazzifun kunfunege muwazzafuna dive rajyege criminal court hukum ko foto ehme meoti adabu devife ehennamas mi gahama mi I think it's open to question dive rajyege gaana lokubat ke dashun kumfunyega maccha ves chinayaka me sabit kureve iru muwazzafun punish ko foto maki kumfunige amal taka oi defense to and that's open to question karne then I'm pretty sure you won't be asked an open-ended question like that for the bar exam I'm told it would be MCQ so this is just food for thought mikamagule gotum then timwana category employment cases and this is a recent development and recent definitely before your cutoff date for the exam and numbers pretty recent and this does not have too many cases one of the cases in which punitive damages was awarded was 209 VTR 2019 Ali Said versus Department of Judicial Administration. So what the Department of Judicial Administration did was they issued a statement about his termination in a manner which was found to be affecting his right to future employability. Wahakeki mustaqbalga ena wazifan hodar enen uraselyan pada gotaka mi bayane news bayane nerefa oin utumuge macca riya ekko punitive damages nagadi fonnani to discourage reprehensible conduct then ega boda bala for huri me Rooks and Bernard usula konnu ega boda bala for America ge me by kaziya taka reprehensible conduct en huttu mattaka tribunal libe barekama me tribunal nimma for onnani ege iturun ege balana factors taku terege kihawarege reprehensible kametto ege me proportionality between the punitive damages awarded and also the actual or potential harm. Then also another factor is the difference between punitive damages awarded and civil penalties authorized or imposed in comparable cases. Yeah, going him masala takuga me kurin nagadi furi punitive damages sa compare kuraro me ekashigama badaletto then iturabes gaziya ga hama ituru factors taka habala defave defendant ki ha musandi defendant to the wealth of the defendant me objective aki benefit damages ke objective aki enen adabedinum kamuga wanya enage musanda kamuga sababon adaben enen evs bire jehilum neti absorb kurevenya punitive damages bodu kura vidanakama dehawa ibaratukun emasalaga hukum ko 40. And then more recently, me nukutaga, and this was after the cutoff point for your bar exam, so this is not entirely too relevant. Ebave private kumfunya ka de kolavs me hama me punitive damages naga difa ali side masalaga naga difa punitive damages ki 1 month ke salary me dennavi pahuge masalaga, which is after the cutoff date for the bar exam naga difa ti demahuge musara. So punitive damages are at present employment tribunal naga de badale, so this is just important for you to know. Punitive damages ke ituru damages ke ba haron mein nimma lafa haron mein hama directly injunctions dana evs suwalen utiya around hama recommend kurang me note kollafa baban wata chetuga lielang erong around hama me dawarakun e suwalaka jawab deveto balan. Injunctions are gule gotum me faha kollan je me mummakamaki, an injunction is an equitable remedy. What is an equitable remedy? I think you would have covered in law school, but I have to recognize that hama candidate terega tibi common law jurisdictions the known hen jurisdictions takon tibi candidate hemema hama wara kurupod dannawanya aron menge divharaje court takon emekeni adalatuge hama ei kuriga ingres vilatuga me common law courts me courts of equity tafat ko foti nms mihar adi I think for the past couple of centuries join with me annani common law hori strict kankang nattalu muge gotum ege remedy ege gotum ache equitable remedies aki me common law rules ma strict ehme mecha luyen hodu mattaka equitable remedies the wujud wekin ai. Then, as far as the Maldives is concerned, we have accepted that we are common law jurisdiction. So as a result, we have equitable remedies available. Then, Miga injunction and Nerumuga Magano Gotega, not the injunction nege me Gano Nusulta Balaro. An injunction is always a discretionary remedy. A Fandiaruge Takadiri Pare. Namaves by Kahala cases, it becomes a primary remedy or the key remedy that would resolve the issue. And that is usually for continuing torts, misalaka continuous harassment. Harassment a continuum daha hindega kotakan yamuru nerevene adi a primary remedy gotka belevigandane remedy actives. Continuing defamation, that is also an instance where an injunction can be obtained. Continuing trespass to the person, continuing infringement of copyright, and also by kahala privacy related torts a primary remedy gotko beleve che me amuraki not injunction. And injunctions are generally awarded where damages or equitable compensation would be inadequate. A fasam badal digen එය එම්මෙ රංගලු හල්ලෙ දෙවේන පද හාලත්ත adequate remedy and දෙවේන හාලත්තකුක අමුරු නෙරෙන එහෙම අමුරු නෙරුම්ගේ කුරින් කෝටුම් බලානේ මේ injunction නෙරුම්ගේ කුරින් කෝටුම් බලානේ damages adequate remedy etto adequate remedy වඤ්ඤා even though you may have a claim where an injunction could be given, it's not mandatory for the court to give you that remedy. General principles of Balayaro injunctions are always awarded in line with equitable principles. Equitable by maxims, relevant by maxims are on court kolla. Equity will not act in vain. Devanakamaki, he who seeks equity must do equity. Equitable remedy the person who is seeking that remedy should be ready. Equitable and thirdly, he who comes to equity must come with clean hands. Gohung amale koffa goes kame koffa, especially in the matter of the or in the context of the case, unfair kame koffa nuata ehmeka gellibe pada kame koffa asse equity ge remedy ka ne devene amuraka ne devene And then there's also delay defeats equity. And all of these maxims, these aren't conclusive, but these are heavy factors. Ma lasvejja. Misalaka me nuisance ge halatuga amuraka miyeden ekan kuttuwa. Ehennama se nuisance hingamundata miharo gaganaka fassaharu wiyo. Ehem vejjeya kotakun e amure nunerun ekashigen be efada halate ifada halatega amure nunerun ekashigen be fassaharu duha kudaraka. Negligence ka around balalani maganu gotegga me silabahoga himene areas the terrain damages for personal injury, pure economic loss and consequential economic loss. A kannenge kuri lectures ka me ma boda cover nu kure areas the hemwegen e around focus ko community. Megatung damages for personal injury agule gotung දිවෙහි රාජ්‍යයේ දෙ හුකුමෙ මෑගණු දෙ හුකුමෙ එබෆාග කුරෙවේ එන් හුකුමකි ihsan versus Ministry of Health දෙවන හුකුමකි Farzana Hussain and another versus W construction masala personal injury ke damages මෑගණු ගොතෙක්ග දෙ බාවතක බහාල විදාන, and this is not something which is set in stone by faharo buying a halat ka guligen nota e kehek effect aguligen e waki tanaka nota waki category eka me nota category badal vedana megaton the key two categories are pecuniary damage ki fasa ge me gello e misalaka treatment nune rehabilitation expense the future medical bills me terenge before way then travel and accommodation expenses may me farwa hodu mattaka daturo ehingawmaka daturo kurumge harada ekawmuga hurumge harada efada harada mi ihsan versus Ministry of Health ka nagadi for farwa lost earnings a Farzana and another versus W construction ga naga devidana farwa ge gotuga bayan ko fehnamas e masalaga me damage විකං සාබිත පදේ ෆනුවාති නගෑනු දෙවෙනකමක් කණ්ඩාලා පවා head of damage දෙවන භාවත්කම වලනේ non pecuniary damage එයි සීදා ෆෑසාගේ ගෙල්ලුමන්නවා මිසක psychiatric damage වෙගෙන් එය ෆරුවා හොදන් කුරා හරදු එයි pecuniary damage එක ගොතුග classify වෙගෙන් දාන්නේ එහෙනම් ඒ ලිබුණු මේ psychiatric damage stress or PTSD or whatever you suffered a suffering naki fasaing me faseha kamako calculate kurane channel and also future employability and loss of quality of life, and I want you to me differentiate between future employability and future wages. Mero future employability ki me wazifa da kurane daira ta kuda wumun elibe frustration e gellun tamigi terem ege me future wages adanya ei hama fasa ge not pecuniary damage ke head ke tereyang government classify korege daaniche. The loss of quality of life I think that's obvious, doesn't need explanation. And pain and suffering, this was awarded in Farzana and another versus W construction, and it is open to question adives kihina to miti min kurani emasalaga amalkofe gotaki ingresi judicial college guidelines ke ache ei ingres vilatuga pain and suffering min kurumuga beenun kura tables takin ega hunnani amugotegga mi waki kahala injury take list koffa e injury takoge e pain and suffering ge range take paya koffa tables takin ei hama mi I had not included a specific table for copyright reasons, but tables takuga hamu goteka mihunnani misalaka neck injury and neck injury ge severity misalaka moderate injury vejja waki range ekala goteka mihunnani ehen hunna iru දිවෙහි රාජ්‍යයේ කෝටොන් ඒ මස්සලාග මේ ෆර්සානා and another මස්සලාග බලාෆ් මෙන්නනි ඒ රේන්ජ් තක රියා කොෆ එමිහන ලිබුණු ගෙල්ලොන් ෆිට්වණි වකි මේ රේන්ජ් එකක් කණ්ඩාලාෆ ඒගේ 1/3 the origin of this 1/3 deduction came from 1143 CVC. They have the Yaminam Dogayim versus smallest police service. Emasala Fundia Shujunge, Gazi Shujunero, Gazi Shujunge, Hukumega 1/3 as a munani to prevent an unjust enrichment one of a basis Gotuga. Sualaki Emasalaga, a liberty Hifetumagule Masale, a Huligama the Immigrant, Mustamataka liberty value, a Divirajak value, or high, a 1/3 a me sufficient. Sualaki personal injury claim. Diviraj a Kudakaragi, Mitaragi Vamanagamaka Vati, Divirajaka suffer kura losses Kudavanito, what a pain and suffering Kudavanito, no Boduanito. But as far as the law is concerned, this is how we do it. A 1/3 a mihar or tapong a deduction egotuga gengule value. And also a loss of filial consortium. A primary victims and nagadeve badale gotuga arunmenna fahaga prevani a secondary victim akang a wahake ke me a toten hingi ero a zone of danger a secondary victim zone of danger a primary victims around the gabu prevent emasalaga nagadi from any primary victims of me a darifolo paraton a mehna libene alaluma o gaterekama a kamagule badale gotuga loss of filial consortium. The basis of it is still unclear. Mati marhala kotek gamihar appeal going masale kama around a gabu preni, so I'm hoping emasala mati marhala court on in their legal basis. A kankamagule gotung explanation the government will begin. But for now and for the purpose of your exam, this is recoverable kama around balage kuria dan. Then the pure economic loss. Pure economic loss around Mikiani Mihaka Nuata Mudalaka Gellume Libumen Neti Toteg Sababon Libe Mali Mihaka Nuata Mudalaka Libe Gelluma Kun Libe Mali Gellumaki consequential economic loss. Mige Misalaki Madega Magega Misalaka. Bike excavate Kuramandaniko, Stelkoge, cable, Burivi, Vargina current a current flowing as a Pokemon, Gina by a current Malibuni. Egg Sabobon, Emihunge, businesses and knowing hinga loss of profit, suffer Kuramun, Dang, Mijiheni. Enamas Enage Mudalaka, a current to get them Sabobon, Misalaka, let's assume my plans of damage and way. Enamas a loss of profit. Suffer above a business no hingu sabab. A situation courts and the general rule is that courts say that the general rule is it's not recoverable. Rajyege anakas miyako hukume aronaka hamagam spaha genwe kureve ename silaba himeneti general rules and me magan exception tang engumaki kama couple kureveti aron me fa kodani. So the general rule is pure economic loss, that is loss independent of any damage to person or property, is not recoverable, a general. And the reason is if the halat takuga me badal nagadem pachafiya me it's you'll be exposing defendants to a potential liability in an indeterminate amount for an indeterminate time to an indeterminate class. Ma ginami hunna wata mi SS nukureveha ginami hunna ege sababon hebagellun libe me e court takon desire kura comment. So in the misal ka electricity example ga around men misnalafia e muli malen current gossiya a huriha emmenge libunu gelluma stel coin badal damage then I'm not entirely sure kina kame stel coin wani, but that is the reason why the law is limiting the liability in such instances. And I have added a note a financial damage or economic loss flowing from personal injury or damaged property is recoverable because it is consequential economic loss. So for an example, me example ka midani Ingresi Court of Appeal nimma was Spartan Steel and Alloys versus Martin and Co Contractors Limited masale. Me masale ki pure economic loss sa consequential economic loss ke tafate wara saaf ko hingiginda masale. Me masale ga hama me current cable ge wahaka me masale ga me oti defendant building contractors negligently cut through an electric cable leading to the claimant's metal processing plant, resulting in a power cut of approximately 15 hours, during which the plant could not process metal. The cable belonged to the electricity company. It was not the claimant's cable, but one melt that the steel company was working on was physically damaged because of the power cut. They were also unable to process 4 other melts. So the claimant sought damages, and including loss of profit for all 5 melts from the negligent building contractor, that is Martin and Co. Ingress Court of Appeal no emasalaga me hold the Kurani. The claimant could recover damages, including loss of profits on the damaged melt, because the loss of profit for that damaged melt is consequential economic loss. A property damaging a both a consequential economic loss a loss of profits a pure economic loss and I say baki we 4 melts a melts a damage weapon way a physical damage and ning halatuga a pure economic loss a under the general rule recover kurevene losses nune. So pure economic loss is in general not recoverable, and then there is the exception. So there is a key exception to the rule that pure economic loss is not recoverable. An assumption of responsibility or a special relationship between the parties. Amu gotegga me exception me feteni negligent advice, not a negligent valuation cases. Misalaka tane value kuram bank account tane value kuram me hawal kurani value ka ege macha e libe malumat ke machan e value ge macha bankun ehe miheka me loan du kurani. Turns out for some reason that the valuer was negligent. overvalue of a property value overvalue of a EOT. E halatuga bankuge usule gotum bank property yaka nuwata bankuge mihaka gellumendu ehen namaves a advice and hodan professional mihaka mi hawa kurani for a reason a rely kurmatta. So in that case there's the assumption that there's a special relationship and that there's an assumption of responsibility. I don't know how misalaka this ituru misalaka sanandana Headley Byrne versus Heller. Me masalaga me Headley Byrne, they were a firm of advertising agents. The defendants were merchant bankers. Headley Byrne ge client and Easy Power Limited ge farathon vara bodu order Headley Byrne libuni ehisabun Headley Byrne benumvi e company ge credit worthiness balan ehme me Headley Byrne ge farathon a client ge Easy Power ge bank CTF onwage malumat saaf kurima e bank on reply kurani without responsibility on the part of the bank ehem me letter head ka bayan koffa city ka bayan koffa that Easy Power is considered good for its ordinary business engagements. This letter was sent for free, and subsequently Easy Power went into liquidation, and turns out the bank was negligent in saying what they said. That was not entirely true. They were not good. They had financial problems, and the bank knew this. Me situation ga Headley Byrne no Heller ge macha dawa kuri e masalaga House of Lords on nimmani amusulege gotum if someone possessed a special skill, if someone who had a special skill undertakes to apply that skill for assistance of another person who relies on upon such skill, a duty of care will arise. And if in a sphere in which a person is so placed that others could reasonably rely upon his judgment or his skill or upon his ability to make a careful inquiry, a person takes it upon himself to give information or advice. A person takes it upon himself to give advice or information, or allows his information or advice to be passed on to another person, and he knows that the person will rely upon it, then a duty of care will arise. Basically, skilled mihako lafe nuata maulumata midde iru e maulumata nuata e advice e maulumata libe farato ege ultimate recipient rely wanakan engenya e halatu gohuriya adi special skill hurifarate vanya am usulege gotum a duty of care errors wani. But mimasalaga, because in the letter they said without responsibility on the part of this bank, me duty of caring assume kuri kamaka nuata me assumption of responsibility with kamaka nufene a House of Lords ke conclusion. Okay, since your exam is an MCQ exam, I decided I would put one question that might help, and this is not at all anything related to how the questions will be on the exam. I have no idea what that would be. Ekamako MCQ suwala hama mi gitere himana laf komisara kami analyze kuram pase awanati himana laf fani. I will emphasize me evasalaga me imtihan going chalon katenge imtihana gulumuri checkam salon ka yagenano. So just take this as something that is part of the lecture to help you understand what I'm trying to say in this lecture. So suwalaki random bank limited kia bank account advance me kurani 1.75 million loan mideni borrow eka 1.75 million rupiah on a property valued by negligent valuer limited at 2.5 million. So negligent valuer tam me value kurani 2.5 million rupiah. Turns out the true price of the property at the time of the negligent valuation was actually 1.8 million rupiah. So negligent advisor me bunane tanaki 2.5 million rupiah tanake, but it turns out the actual value of that place was at the time of valuation 1.8 million rupiah. Subsequently, the borrower defaulted, and also the market value of the property fell, and eventually the property was sold for 950,000 rupiah. So the question is, what is the damage Random Bank PLC could recover from negligent valuer limited? I have, I think, 5 options here, and the number one is the difference between the negligently valued amount at 2.5 million and the loan amount. Option B is 2.5 million minus the price with which it was sold. Option 3 is the loan value minus the price at which the place was sold. Number 4 is the difference between the negligent valuation and the actual valuation, and number 5 is the true value minus the loan value. So we can do this by exclusion easily. Furitama kamaka, we need to note that the market value of the property had fallen. So the true value at the date of the valuation was 1.8 million. Valuer advice there me advice deniki market ang annana badaltaka market stable ko hundana kamakasha enage duty scope of duty ko ake anakas beden enage scope of duty me limit wani me eduwahu ena valuation hedi duwahu etanu aga. So which means the subsequent difference 1.8 and 950 ademeduga me tafat, that's not damage that they could be held liable for, which excludes 1.55 million 950 then me 800,000 value because a market value losses is make it. And then there is the question of the 750 or 50 year. So 1.8 million naki etanuge valuation. If they had not been negligent, they would have said 1.8 million etang value. So 1.8 million na a loan na other. This would have been there even if they had not been negligent. So this 50,000 is not going to be the recoverable damage. And this 50,000 is actually included in option A. So the difference between 2.5 and 1.75. So these two options are not correct. So finally, we have our final option, 700,000. Kihinatto mi adadu mihin mi wani. Around Kurin then general principle a Livingston versus Royards Coal Company. A analysis of it is likely to mislead in negligent valuation cases. It is likely to mislead. So Miga Hagigatoga Benkam Milibunu Gilumaki, value duty of Bala, Benkam Milibunu Gilumaki, they lost 700K of security that they would have got or that they would have tried to get in the instance where like they would have known misalaka 1.8 security 1.75 million ge loan me dukurani 2.5 million ge security libena kama balape what they had lost was that security. They thought they had 2.5, but they actually had 1.8. So that difference is negligent valuation cases. And these are actually the facts of Sampo case. Sampo principle principle and they have one nimma masale. Masalaga terega tin case and appeal for India, egg terrain, ek hoge facts hagegatuga me. And the Court of Appeal had got it wrong too. So if you think this is too hard, then that is the case because this is complicated and see the value of Supreme Court on the House of Lords some of Fude Varege Masakate Miga Koffa explanation the for it coming me. So there's that negligent valuation ultimately make a summary negligent valuation compare Kurani a negligent valuation thing overvaluation aslo emena debuno property aslo aga. So that means the difference between 2.5 million the negligently told value which they thought they had and what they actually had a 1.8 million. That's the damage that they are said to suffer because that is the loss of security that they have. So it is almost 1 hour since the lecture started. So I will take a break of about 5 to 10 minutes. But before the break, Miss Suwal Duko Lafa break money. And this is a similar question. And I have explanations for some of the answers. Mia MA demme dia ke hoge tafata ki the loan value is actually this is 11 million and the property valuation given by the negligent valuer is 15 million. The actual price is the actual valuation of that property is 5 million. Now, Kuriga case compare Kuriga case the loan amount was still smaller than the actual valuation. But in this case, the loan amount is actually larger than the security amount. So the question is, mi situation ga kihinetto conclusion naka annani kobato miga nagadevene farwayaki. And miga was anaka some me samakan them scope of duty. A value scope of duty a key kobato is what. Then Miss Wall do laugh around 5 to 10 minutes exactly 10 minutes breaking nakana. Yes. Every sual and otia around the සුවල් නැති તો
yes අලුකට ගත අනේ සුවාල නේද අනේ අඩු සාපතෝ
අඩුතා yes
yes අලුර ෆුරුතම් සුවාලකි බෙෆ්ලා ෆාක් කොල්ල වි ඩොක්ටර් හාන්ගේ කේස් ඒ
yes
කේස් ස්කෝප් ඔෆ් ඩියුටි කෙයා බැලීරු ෆාග නොකොල්ලවා කන්නගේ ඩොක්ටර් හාන්නකි ප්‍රොෆෙෂනල් දත්ත
yes
ඩොක්ටර් so duty care and haywana kamalu gada ngifeni ma professional level you have to say e kahala ituru miha ko emagam go horege nagani kon decision netto belu and duty of care enage duty of care tere wade to yagin kurmatta ka balani hen ehento divehi rajye gaves balani professional duty of care ya and ordinary duty of care tafatu kurumtaken horeto ei eke then devana suwalaki ane then kuda kon concern we come me and England one nagade damages ke 1/3 dive rajya nagadani then reason inna kattibunani dive rajya ki taragi wamun anna gawm ekkamu evaluation e waruga kuri it would be unfair kama de alwaruga suwalaki misalaka rajya ge taragi befa mata international spectrum ga hama leading tan industries gotu gamiti be tourism industry ge tere mikahala negligent issuing as siyaves nagadeni hama 1/3 to nota hama full value nagadin argumentation geneveneto the a deswalake
okay so khan ge case ka yes professional me negligence ke halat so medical negligence ke halat ga essentially mega me balani England gas then rajya gas buying hukum taken we don't have any authoritative decisions on this ekam aam gotega me balani a situation ga එහෙන් මේ reasonable doctor අප අමල් පුරාණ ෆාද ගොතකත්තෝ යමල් කුරි it doesn't have to be like කීක මොනානි if there's room for argument then no if there's room for disagreement then a negligence ke standard for him wakamaka no belevene numbers if it is clear on the facts that no reasonable doctor would have done this reasonable doctor would have done this then they will be found to be negligent thing rajye civil court ga a bahuri me by decisions me naga then I'll point out that medical negligence is pretty much a very specific area of law and I have been told that it will not be part of the syllabus per se. So that is the answer to that question. Then one third issue, we have personal disagreements with the court. Like I personally disagree. One third valuation na medo hen namaves rajya court takom balagana foti rajya court takon nagadeni hama 1/3 kama ingres ilapge me dates takoge and that is something which is on appeal as far as I know me Rajya High Court and appeal ko feke koi a 1/3 a deduction a hama me rangalo gotetto and if we consider 1143 that was a decision made back in 2010 and me effects hinga de compare coffee miharu is some significant developments like if we are comparing hukumu me gunani taragi fai kauma taragi wamangana kauma reason ka dakka foti and I think if we look mihara balafia hama since then we some fudevarage tafat take rajyege community was samyoti so whether that it will still stand is open and for the purposes of the exam the law as it currently stands is democratic society aggressive life for the democratic society 1/3 and I will point out ane America ge me case ka rely of me filial consortium naga dingiru 3143 series ide hasti ega and a goes hama a 1/3 get deduction me annani say unjust enrichment vedanati kama gune anna deduction so that is how it is at present but I see your point I actually agree with your point then misalaka rajyanga and foreign investor ge halatuge sehento not rajyega and tourist ge halatuge samay 1/3 deduction to most likely rajya kotakun egota balani at present yeah did I help with the questions?
yes thank you
Okay. ඉතුරු සුවාලෙන් ඔතිය සම please ask.
ඉතුරු සුවාල නැකම බලන්න බ්‍රේක් අදමදත්ත
දෙගොත around this බලාගෙන් around හම resume කුරාණ sharp 2:15
ශුක්‍රියා
Okay. Huriha Baring Sikama Balani bring in 40 participants, but right now there's 37. MM Madukalani join Kolata. Maron Fashana. Missualuga. Thing option me me option A hamakuri sualuga me security ge me difference. Devana option community loan amount minus a Vicarious and the Bunavaro 8 or damage key value Paratum claim Kure than and Timon option. But for the negligent valuation, a Rangalang a value Kurinama, a Benkong alone and Udene. Me option taka bala aero one could argue that the right answer should be C, and this argument was made in the UK Supreme Court West, but the Supreme Court decided that Miga Hama Rangalo Hama a Losegi Nani, regardless of me whether they would have lent or not, me other Kama, and there is a reason for this. So, what negligent advice, what a valuer, negligent peers, no yes, what a valuer undertakes when giving advice isn't about whether they should make a loan or not. वाहकेकी लोन मी लोन देशे नो तनु देशे के नूने valuer में पुरानी valuer दे मालूमात उस valuer दे advice में सागे तो कमी खंडेले गंदानी क्या वारेत्तो a loan के दर्शन दो कुरंचे. This was the argument that succeeded in the UK Supreme Court. Me loan at dinumuga ega balan jehe me kihawareke me security. So that's one factor. Ekam kege itura loan dinuman nimumuga hama bala itura factor taken ebahure misalaka past credit worthiness of the borrower's responsibility take mege terang annan jeheta. Then hama me but for causation on dam vejja borrower a default movie nama bes damage nuane e sama negidana argument. So a but for causation ge itura ege terenge bandinje legal causation or the legal responsibility. That is the essence. And a responsibility may limit one within the scope of the duty that was assumed to have that was assumed by the valuer. And that is the reason why it was still limited to the damage that they the loss of security ke value loss of security me bunani a negligent security ya a aslo a tang value ge tafat. Then if you want to analyze this from the Livingston general rule, you will have to make the assumption that the bank would have done something like add more security and gotten that value of 15 million as security had the wrong not occurred or had the negligence not occurred. Wahakeki me learn million loan dinumattaka bank ge faratung ehem mudalen hodagem bes 15 million ge security bank hodan assumption na nula a framework analyze kuram kashafiya you will be misled and undagu wan me jawaba but if you assume that the bank would have me done something and got that 15 million security, then this is very straightforward. And in the other case, misalaka, without that assumption, if you try to think about it, nukuna nakijaki, regardless of the negligence, etang value etanang ilibeni. Wahakeki negligence nohingi nama hunna nadudaki kobato bala aero rangalu value de 5 million. At the date of valuation it was 5 million. So a damage nete to a conclusion ki ehem wa vejjam that doesn't make sense. So ehem vegen me midennavi a assumption nang annan epaje a framework on analyze kuranya that the bank would have done something added more security and got that 15 million security for the loan worth 11 million. I hope that helps, and I think that is the end of negligence. And then around me requesting as the message on judicial college guidelines say for copyright reasons go educational exception, but this is I think will be published on YouTube many, but for a small bit judicial college guidelines example ega mihunani misalaka moderate brain damage type 1 moderate damage type 2 then meethana fall way to eba belumuga jehena expert witness not expert evidence hushala husha nala timanne libuni me less severe brain damage and minor head injury kenwata if that claim kogene you will not succeed. So you will have to first prove me can suffer with damage ki ehisabun ege pain and suffering ge gotuga me range me fall ani whatever the court decides me range ke terrain you would probably be reimbursed. And on one of the questions that I was asked about 1/3, I will just point out 3143 CVC has Navara Gaves Hama Bidesing Takedawa Kuriego some 1/3 apply for team around within the Hama in the futures most likely Hama 1/3 deduction Neke Mega again Gulung money unless this is overturned by the High Court or the Supreme Court in the future. Okay, defamation. Mega put a clarification on for the Mijani. Aming Kurigi lecture egg Bonave Febave, Abraham Suburban Libel, Badan Gatin Kawai, the key Miharo, Amal Preve Kawai, the Noonkama. So I need to clarify this. It is still law and mige legislative history balali megen hama mi olung ekshegen wa nota e kahalagotaka mige history balafe hama e kawaitu mi sorry ek kanun dashan anek kanun badal anekka ega kanun badal foi kawai demmi so emme furitama mige legislative history anun midani emme furitama mi kanun himenuni sorry mi kawai himenuni mi amu kawaitu ke kanun ge jadwalu dek me 2008 ga ಆ ಗಾಣನ ಸಾಸಿ ಪಾಸ್ ಕುರುಮಗೆ ಕುರಿಂಗ್ ಅಮಲ್ ಕುರಮಂದಿಯ ಗವಾಯದ ತಕ ಗಾಣೋನೆ ಬಾರು ದಿನಮಗೆ ಗೊತ್ತೊಂಗ್ ಹೆದಿ ಗಾಣೋನೆ ಆಮು ಗವಾಯದ ತಕ್ಕೆ ಗಾಣೋನಕಿ the intent was a ಗಾಣೋನ್ಗೆ ದಶಂ ಹೆದೆ ಜದ್ವಲೆ ಮೊನ್ನನೆ ಜದ್ವಲ್ ದೇಕೆ ಮೊನ್ನನೆ judicial no tami court takaguಳೆ ಗವಾಯದ ತಕ್ಕೆ ಜದ್ವಲ್ ಎಕೆಗ್ಗ ಹೆಂ ಗವಾಯದ ತಕ್ಕೆ ಮಿನಿಫಮಿ ಮೊನ್ನನೆ then ege intention nakam oti temporary ko e gawaytaka baru difa e gawaytaka gule kanun hadafa e kanun hedumaka e gawaytta ubigin danu. That was the initial intention and ege initial duration ka stifati eng aharo but ane e kanun go oi eng aharo doha mi eng aharo dos weimano eng aharo dos umge kuring majlihuge committee pass ko majlihum pass ko gen e gawaytaka amal kurunge muddati ituru kurevene. So what happened in practice was jadwal takori kanun sorry jadwal takori kawaid taka ganun nuhedi hama komme harko extend kurevamo then by ganun tan hedemun but that was slow and miharos adives hama yearly extend kuramun anna mi jadwal takemmi. Then there is an interesting situation mega a Musa Anwar versus Divehi Dawle has agar HC-DM oblique sumeng hatare gazi yaga Divehrajje high court on kandala fumennani e ganon ge jadwalu tapuka himene gawaidu takaki ganon asase solona madage hage beenuma ganon ge bike वाके के जदवल तक नूने गाणों के बाइकी एहनम से जदवल तक लिस्ट को पूरी गवायद तक की वेस गाणों के बाइके हम practically what we are saying is me गवायद कियस me गाणों के that is what the High Court has decided and that is the current law. This is questionable personal views hunnamvi but this is how the law is at the moment. That is how we will go ahead. Then me gavaid ekara August has solage belenuri kanunaka aburu rakateri kuruma khayal pala kuruma minimum kamuge kanun. I think if you had followed eruge legal developments. You would know this act a aburuge kanun a criminal me adaptakin himinigen way kanune එහෙනම් ඒ ගානෝනුගවස් මේ ගවායද තමට අනේ ගානෝනුගේ තේරවන මාදගේ ශාවීනියක මේ පුණනේ අපරාභම සබබුම් ලිබේ ගෙල්ලුමුගේ බදල් නගෑදෙවෙනි අපරාභම සබබුම් ලිබේ ගෙල්ලුමුගේ බදල් නගෑදෙනුමා බෙහෙ ගානෝනුගේ දශන්නේ දැන් නෝනුග මෙන්නනි ඒති මේ ගානෝනුගේ දශ ඒ ගානෝන ප්‍රහායින් ඔබ්ජෙක්ට් හසාෂෙක්ගේ ජාදුවලුගේ දිහවන නුක්තක බයංක ෆෝ ගවායදුගේ බෙලෙනවරි ගානෝනේ කමුගා මේ ගානෝන හමුජෙකේ. And then subsequently, again, aburuge kanun uwalu ma ekko 22 November 2018 ga alum aamu gawatke kanunuge jadwala me ituru egen die in and it's mentioned in ama e kanunuge devana mataga safko e hain of the 2018 ge devana jadwaluge devana nuktaya alum himana e gawatke belenere kanunaki aamu gawatka behe kanune. And then hama ege fahon majlihon just before the exam cutoff date majlihuge gawat committee nimma for report uga hama jadwal deka himene gawat list ko fain iru ting gawat meonnani e shariya kurma behe hadifa gawat 5.1 shariya kurma behe hadifa gawat 5.1 sumen ade aburabun sababu libe kellum badana kadinge gawat then 2022 ga committee mihar fast koffoti air me committee mihar fast koffai gotaves gotu gaves me mihar me furitama de gawade no himene ehnames emme faho gawade aburabhen sababun de begellum badal nagade no gawade 2022 gaves himene fa ebave hamai jadul de himene gawade gotuga. So as far as the exam is concerned, this is pretty clear. A gawada ki amal kurevum da gawade, and it is essential reading. And I say essential because a gawada ke bohuri fude waraka tafsir ko difa abura behamuga me liable ki ko bato slender ki ko bato possible defenses ki ko bato absolute privilege wa halat ki ko bato in komme defense ke tafsilu se ke difa bohuri. So I won't go through the entire gawaid or the entire regulation me lecture because the regulation is very detailed. Ege bahuri hama specific me defenses of all one me halat tak. So essential reading, please read it. Exam essential malumat ege himene ne. I believe it will be part of the since it is a part of the law, it will be part of the exam, and this will be assumed to be part of it. Then a gawadu nuhimene kame authoritative decision maker eba oi wahakeki something that you should be aware of is can a court order an apology maafan eduma courtum amuru kurevidanato abura beche halateka e gawadu ge babune maafan edijjeya gellumge badalu kuda kurevidanaye nata gellum badalu kuda kurumge factors taku terege boy maafan edu suwalaki ಕೋಟ ಅಮುರೆ ನೆರಿಗೆ ಮಾಫ ಎದುಮುಗೆ ಸಾರಿ ಮಾಫಂ ಎದುಮುಗೆ ಅಮುರೆ ಕೋಟಕ ನೆರವಿದಾಂತ ei ekkotukambunya mandatory injunction ನೆರವಿದಾನ ತೋಯೆ ಮೀಹಗೆ ಮಚ್ಚ ಮಾಫಂ ದೇಶೆ kiya misuwalu jawab dibe rajya high court difati ei Ibrahim Ismail versus Ibrahim Muttalib masalaga dibe rajya high court nimmafa onnani ei purevena comment nunka. And their reasoning was this. Ekaku anekaku ge kiba maafan eduma ekaku aneka maaf kurumaki buna bahakaburan bodan insani ihsase kama bi hindu gadakamu majbur kogge maafan eduma gadakamu majbur kogge maaf hodumaki maaf ke tabiyata khilaf kame kamuga beleben wen utumasha gaanuna kunnata gawaidukum bar lib fanetis abura behamu sababun dibe gellumge badaleke gotun abura behamataka mihek bunefa haki dogu wahattake kama bune abura behunu mihage nuruhumuga ekama maafan eduma court takun enen amur kurumaki minivan demokrati mujtama takugaves kankon ule wekkan istinaf prata sabit ko defanite. So essentially this sababaki maaf ke tabiyat maafan edumaki akhlaqi moral kame ಕೋಟಕ ಮಜಬೂರ್ ಕೊಗ್ಗೆಂ ಏಫದ ಅಮುರೆ ನೆರವೆನ್ಯ ಎ ಮಾಫುಗೆ ತಬಿಯತ ಖಿಲಾಫಕ್ಕೆ ದೇವಣ ಕಮಕ ಎಬ್ಸ್ ಕಾನೂನ ಕೊನ್ ಮತ ಗವಾಯದಕು ನೆತೆ ಎ ಕೋಟಂ ಏಫದ ಅಮುರೆ ನೆರುಮ್ಗೆ ಬಾರು ಲಿಬಿತಿ ಫೈ ಏಫದ ಮಿ ಬೈ jurisdiction taka e bahuri e fada amure court me ba e fada amure nerum ge bar court taka difa ekamuko ekan ko onnani kommes kanuna konnota kawaido. So in the absence of such a legislation, Vicarious se fada farwai nage deve. Vicarious liability ge factors taka maaf kada test ang ekani around balalani mige tafsil takaka around vettana kurige lectures how kure furi back kemmi usule goton den Vicarious ge vicarious liability recognized ko febbe San versus Ministry of Health adi Farzana and another versus W Construction Company masanaga. Then at common law, an employer is vicariously liable for a tortious act such as negligence carried out by an employee in the course of employment. It is a form of strict liability. Mege testan around men bala ero furatama suwalaki e gohu e madani goes no te tote commit kuri mihaya and enage me employer kama me bunanwata e strictly liable wa fara kama me buna farata de meduga ebettoe e for the me liability and establish kureven for the relationship, and usually this is employers employment liability, and if it is an employee, and there's definitely room for arguing that, that there is vicarious liability, and usually that is how it will be held. Independent contractors ge halatuga komme swarage suwale upedidane and numbers so far as it is similar to an employment relationship, and so far as there was control over the person, it doesn't matter the type, exact type of relationship, as long as me punahem vicarious liability and established kureven for the gap kame defarat ko demed goti ay control ge element e hamaki miga, and that is the same employment to independent contractor to belomugo sama benu pura essential test me me contract gonna now muhimme nune me substance ega muhimme, so that is how this works as well. And even if the person is not considered an employee, there are situations where the court will still say it is similar to employment, so we will impose vicarious liability. Devana kamaki wazifaga ena adakura kankamuge terein nota me kankama bala iru ene kurikamaki enage employment employment ge kankama gulum huri kametto kiha gulumen huri kametto. So misalaka me construction worker vejjamu warasape construction masai kurumuge terein hinga kame vejjeya negligence kame base and liable hennamas misalaka say travel agency counter gonna me me customer kama ena bara hingam nuje me hemi ai ama gossa commerce ko hamal deena mara swalaki ehalatuga me employer liable manato. And I think the obvious answer that I think like we would be thinking of is, wait, that's not entirely like part of the employment, although it happened in the place of employment, although like a employment ki sababun e opportunity libune, but a personal vendetta, personal vengeance e kahala kamen e getere wade fotati a course of employment mata me field of activities ge terega employment ge field of activities ge terega himene kamakan nuati, that will not be considered a situation where vicarious liability applies. ega balang bejhe me hama insaf kama employer bes insaf kama impose kurave liability etto ei hama me key question ne. So me dekantaka naganu gotegga me balane den we ge second limb ge terega ebawade me two me sub test e dekama me balane obato ene hudda vegema field of activities ki devana kamaki ene kuri kamaki activities za kiha warage gulumen hore kametto. The closer it is to the type of activities that he is authorized to do or she is authorized to do, then the higher the chances of vicarious liability being established. The further away it is, then a liability chance and that is essentially it for the lecture. Miga evves swale mi cover kuran topic taka gole evves swalen utiya you are open miharwes swal kura. I'm assuming gina candidate YouTube ang upload kurone ma fahunne balani so එහෙම වෙගෙන් contact details around දුකලා මෙති around me Viber WhatsApp around කුලේන message කරේන preferably I would prefer messages so I can reply in writing, and emails also preferred over calls. I will just point that out. But if you have any questions, Mihar Hama, please ask away. But if not, I'm a fahun swal curious. Ebet swal.
Misapang visual nekamo balafa mi lecture ni makagananan ding mi first ba adifar ba council ge namati mara boda also Shaffan shukuru ada kurang mi lecture kuda gendra dini ding evidalu heng hama huriha lectures eves armenge mi YouTube channel adi mi aspiring lawyers platform on Teams ka ves available one waka denne shukuriya bara boda.